Chilton County tonight. When I got here and set up, I told this young man right here that I didn't want to yell too loud in his ear standing in this spot, which just worked out where the room is set up. And he said that's okay. I'm hard of hearing. That's why I picked that spot. you let me know if I get too loud. We're going to talk about the Stand Your Ground law tonight and what it is and what it isn't, when it applies and when it doesn't. I just want to say thank you to BamaCarry. I spoke at my first BamaCarry meeting in early 2018 in Jefferson County, and I think this is my 14th and 15th. Since then, I have been, BamaCarry is a client of mine now in my practice, and I'm glad to be serving in that regard as well. So, the Stand Your Ground law is something we hear about. Most states have it. I think it's 37, 38 states have got some version of the Stand Your Ground law, but it's a little different than self-defense. It's certainly different than the Castle Doctrine. And so, just to give you a preview of what we're going to talk about, I want to mention a couple examples to you, just right off the jump. If you walk outside tonight and someone has stolen your car, and you see the taillights from your car leaving your driveway, can you go out there with a gun, fire at them? Does the Stand Your Ground law apply to that?
Nope.
No, it doesn't. We're going to talk about why. Okay? There was a movie in the late 1970s, I'm dating myself here, called The Sackets with Ben Johnson. Everybody ever see that movie? It was an old Western movie. And there was a scene in that movie where there was this young buck who was causing Ben Johnson problems. And not to give the movie away in case anybody's going to rent it. Well, you can't do that anymore. I'm dating myself again. Ben Johnson pulls out a shotgun and shoots the guy at close range, blows him in half. They said, "Why'd you do that?" And he said, "Well, I just got tired of him wheeling me around." All right, is that Stand Your Ground? Probably not. I brought this stapler here. Now, I want everybody to see this is a stapler. All right, get a good look at it. But if you walk outside in the dark tonight and you see somebody in the shadows doing this with this stapler, is that a Stand Your Ground scenario?
Yes.
It may be. It may be. So it's about what is reasonable, and that's what we're going to talk about. And I'm going to allow time for questions at the end. I'm going to speak for about 12 or 15 minutes, and then the rest is going to be questions. Now, in these packets, if everybody's got one, I've got more up here. I may just leave these in case anybody else who's not here wants one. I can also email these to you. I've got my cell phone number on there as well, and so all my contact information is there. There is a bio about me in here, so if you need a cure for insomnia tonight, hold on to the packet. It'll put you to sleep right away, I promise you. So, what is the Stand Your Ground law? It provides no duty to retreat, and it justifies the use of defensive force if you have a reasonable belief that there is imminent physical force about to be used against you. And it has to be what you reasonably believe is necessary for the purpose of protecting yourself. And I pulled the definition of reasonable belief just straight from the Alabama Code in here. It can't be a reckless belief. It can't be a negligent belief. It has to be what is reasonable under the circumstances. It does not have to be a correct belief. My stapler example, all right? You see the barrel of the stapler pointed at you, and somebody has threatening language. It resembles a gun. Well, it's not a correct belief that you're about to get shot. You can't get shot with a stapler, not by a bullet anyway. but it might be a reasonable belief based on the circumstances around you. It depends on the circumstances at the time. Now, how is stand your ground different from self-defense? How is it different from the castle doctrine? Self-defense is just a defense that you have. That it's a common law defense. It's as old as the law is. That is justification for using defensive force. It is a defense that a jury, if you've been sued or arrested for using defensive force, a jury could say, we find this person was using self-defense, and they're therefore justified. The stand your ground law goes a step further. The stand your ground law is a form of immunity, which means you cannot be put on trial. Okay? Those of you who were at the BamaCarry conference up in Jasper in February, I know some of you were. My friend Greg Hopkins spoke there, and Greg Hopkins talked about how, you hear people say, well, I'd rather be judged by 12 than carried by 6. That's not the standard under the stand your ground law. Under the stand your ground law, if you have been sued or arrested for using defensive force, you have the right to a pretrial hearing where a judge hears the evidence and decides whether or not to grant you immunity. And if you're granted stand your ground immunity, meaning you were justified in using that physical force, then it's over. You don't stand trial if you're granted pretrial stand your ground immunity. Okay, and this is important because when the stand your ground law was first passed in Alabama a decade ago, there was no. It didn't say whether you got that pretrial hearing or not. Other states did. I had a case in North Alabama where before they changed the law, and I said, Judge, I'm entitled to a pretrial hearing, and they said, well, we'll just do it, on the same day as the trial, then roll right into the trial. Well, now in 2017, the legislature changed the law, and you're entitled to an actual pretrial hearing on stand your ground immunity. Okay. Now, as I've got the definition of immunity in here, so. How's it different than the castle doctrine? The castle doctrine used to be the law in most places. It goes back to the old saying that, a man's home or a woman's home is their castle. And, under the old castle doctrine, if you were in your home, and somebody tried to come in and do you harm, you had the right to defend yourself in your home. The stand your ground law transfers those rights that you used to have in your home to anywhere you have a right to be. Okay? If you're in public, if you're in Walmart, if you're in a hotel, if you're in at a friend's house, it takes those same rights that you had that you used to only have in your home, and it gives them to you anywhere else you may be. Okay? Here's the key. You must be somewhere you have a right to be. Okay? You cannot be the initial aggressor. All right? And you can't be breaking any laws. If someone using defensive force does not satisfy those things, then they are not entitled to stand your ground immunity. Okay? Somewhere you have a right to be, not the initial aggressor, and not breaking any laws. Let me give you a real life example of this. There was a case up in North Alabama a couple of years ago where you had a drug deal go bad. All right, and one of the participants in the drug deal shot and killed the other participant in the drug deal. He's indicted for murder, and he goes to court and he asks for stand your ground. Hey, I thought the other guy had a gun and he was going to kill me. All right, does stand your ground apply to that? No. Okay? You can't be breaking any laws. And also the guy had a prior felony conviction and didn't even have the right to have the gun. So he was breaking the law a couple different ways. The judge correctly said you don't get stand your ground immunity, but yet he was still able to go to court and say self-defense. Just because you don't get stand your ground immunity doesn't mean you can't use self-defense. You can always plead self-defense. It did not work for him. He was still convicted by a jury, but he did have the right. He did have the right to plead self-defense, even though his stand your ground petition was denied. So that's as far as the other examples I gave. As I've been around the state, a question that always comes up is am I justified in using deadly force in defense of property? And the answer is no. All right. If somebody is stealing your car, if somebody is tearing up your fence post, if somebody is bashed in your mailbox, okay, those are not situations in and of themselves where it would be reasonable to think that you are facing imminent danger. Now, what they're doing is illegal. It's aggravating. They ought to be prosecuted for it. But that is not a situation of stand your ground immunity when it comes to defense of property. There's a situation in Coleman County right now. I mentioned the car being stolen, where that actually happened, and the owner went outside with a deer rifle and fired. I don't know if he was hoping to shoot out the tires, stop them, warn them or not, but unfortunately he made a direct hit with the driver and is now being charged with manslaughter. And that's what can happen when somebody uses deadly force in defense of property. Okay. Now, I want to mention a couple things to you. There's a lot of talk. People ask me about insurance or what kind of protection can I get. I know y'all hear from people trying to sell stuff. I'm not trying to sell anything. I'm approved counsel for the Self-Defense Fund and the USCCA, so they don't pay me to give them a plug. I would just say it is something that's worth thinking about, not just from a criminal standpoint, but also from a civil standpoint. If you are involved in a situation of using defensive force, even if law enforcement and the district attorney, says, "Hey, this is clearly self-defense. We're not going to touch this," that doesn't mean you can't be sued. Okay, and if you're sued, then even if you win your lawsuit, you face tremendous financial exposure. Lawsuits are expensive. It takes money to defend oneself in a civil lawsuit, and so it's worth looking at. I know there's a lot of options out there about what is available to you if you find yourself in one of those situations. Before we go back to the law, I just want to mention a couple of stand your ground cases that my firm and I have handled for BamaCarry members around the state. We've had a couple of serious situations. We had one up in Wofford County that you may have heard about, where a young man was spending the night at a friend's trailer, and they woke up on Saturday morning, and there was suspicious activity outside the trailer. There was a guy looking in the windows and trying to look through the door, and they retreated to the back of the trailer just for their own protection. And then they come out, and the door had been open. It was ajar, and young man's truck keys were missing. They went outside, and this burglar was in one of them's truck, attempting to steal their truck. Now, in this situation, it's a little different than the example I gave you, because the truck thief saw them and turned the truck towards them and started trying to run over them. Okay. One of those young men was armed, and he eliminated the threat. And fortunately, we were able to get involved early on, and he avoided any type of prosecution, because it was clearly a situation of stand your ground. You'll see in the packet, the most common form of stand your ground immunity is defense of self, a 101. It also applies to defending someone else. If you see someone else who is facing a deadly threat, and under the stand your ground law, then you can defend them as well. And that's actually what happened here. My client intervened just before the truck hit his best friend, who was standing just a few yards from him. Another situation we had over in Marengo County, had a BamaCarry member, an SDF member, who was arrested. This man's a law-abiding citizen, and he was out on some family land running his dog. And his dog is a pretty small dog. And up the way a little bit, there's a troublemaker who just got out of prison for cooking meth, who had a bunch of troublemaking dogs, like pit bulls, that had terrorized this neighborhood. And this pack of wild dogs start coming towards this man and his small dog. He happened to have a shotgun in his golf cart, and he fired the shotgun. I don't think he even hit the dogs. He just hit the ground, and the dogs, the wild dogs, got up and ran off. Well, the owner of the wild rabid dogs wanted to cause some trouble, and he went to the Marengo County Courthouse and persisted, and gets a warrant for animal cruelty. Animal cruelty. All right? And so I got involved, and we filed for a stand your ground hearing, which was to take place on April the 2nd of this year. And so we researched it, and from what we could tell, it was the first ever stand your ground hearing for using against an animal. But the law does not exclude animals, and this is an animal cruelty case. They say their animal was hit, and so we felt like the stand your ground law applied. And so, not to stand up here and tell war stories all night, but we went to court down in Linden, and we were on the front row, and my client was there, and Bruce Wade was sitting there too from BamaCarry. And it's a crowded courtroom, and the complainant, who had a lot of experience in that courthouse, shows up, and he's got his posse of people with him. And the judge calls the DA, the complainant, and me up to the bench, and the complainant started mouthing off at the court, at the judge, and the judge just said, "Hey, just chill out, calm down." And but there was no stopping this guy, and finally, well, to make a long story short, my client was discharged, and the complainant went to jail. He ended up mouthing off to the judge. The judge said, "Look, be careful." And then finally he goes, "Look, I'm dismissing this case." And he gave him 5 days in jail. And then the complainant said, "What the something is going on?" And the judge said, "Make it 10." And the funny thing was, as they were frog marching him out of the courtroom, the complainant stuck his head back in and said to his girlfriend, "Hey, call my lawyer." Well, good luck with that. We got kicked into jail. But anyway, so there are situations that any of us could find ourselves in. The thing that where these two cases are similar is neither person woke up that morning planning to find themselves in that situation. Okay? But they were put in that situation, and they were forced to make split-second decisions. What am I going to do to protect myself? What am I going to do to protect my friend? And so and I hope none of you are ever in that situation. I sure hope I'm not. But the reason why we're doing this is just to make y'all a little more aware about what the law is, and so that you know what the law is in case, God forbid, you are in that situation. Okay, and I hope you're not. Now, I've got a few more things about the about the law here, about when it does and doesn't apply. I mean, certainly if there's a home invasion, the law presumes that if someone is breaking into your home, that they are presuming to do you harm. But situations where it doesn't apply, I already mentioned you can't be breaking the law, you can't be the initial aggressor, you can't be fighting with the police. All right, as long as the police are carrying out their duties lawfully. A good way to remember it is, and I've got this in bold in here, is lawful place, lawful time, lawful reason. You know, in my career for the last 18 years, I've seen a lot of different situations. I've handled criminal cases, I've prosecuted criminal cases, and most people who get in trouble with the law are somewhere they shouldn't be. Okay? And the stand your ground law is pretty consistent with that. You've got to be somewhere you're supposed to be, or at least somewhere you've got a right to be. Now, there is one thing, I always mention this. The law says the physical force involved cannot be the product of combat by agreement. Okay, so if you're in a duel, you know, don't plan on saying stand your ground if you win the duel. Right? That's in the law. Cannot be combat by agreement. And when I read this, I thought, well, you know, why'd they even put that in there? It seems a little, a couple hundred years outdated, right? We don't have duels anymore. But then back over the summer, did you see the story about these two knuckleheads out in Arkansas that got drunk and put on Kevlar vests and were shooting at each other? So, if that were in Alabama, I'm not sure about Arkansas law, but stand your ground would not apply in that situation. Okay? Key points just to wrap up, and then I want to get to your questions. I've talked long enough, is you have the right to stand your ground so long as you aren't breaking the law, you're somewhere you have a right to be, and you were not the initial aggressor. All right, those are the high points. I'm glad to take your questions, and then if you have any questions beyond tonight, I'll be glad to take calls or emails. What's on everybody's mind? I know I wasn't that perfect. Yes, sir.
If you're inside your home and someone is from the outside, if they're trying to break in, how does the law apply there?
If there's a home invasion or a robbery, then yes, in most cases it would apply. Now, if someone is, just out fooling around with your stuff, handling your stuff, that's different. But if it's a forcible entry, then in most cases, generally, that's going to be a stand your ground situation.
You don't have to wait till they get inside to defend yourself.
Well,
they're attempting to get inside.
Well, if someone is attempting to get inside, then that's there's a question of how long you have to wait. But at that point, it goes from stealing to doing you harm. And so when it gets to that point, I think it's closer to a stand your ground situation. And I don't know of many prosecutors who would prosecute a homeowner who defends themselves to somebody coming inside their house. Okay.
I just know like a lady in the house, her husband is working, lady in the house, two small children. She ain't got to wait till he comes in the side.
Right. In that situation, you think about what's reasonable, and what's reasonable there is that Mama's going to eliminate the threat. Okay?
Thank you.
Yes, sir. Any other questions?
I got one.
Yes, sir.
Something we Paul was talking about earlier. If you're in a self-defense situation and you're not the aggressor, somebody fires at you, you fire at them, you hit them and the bullet passes through and hits somebody else.
I think it goes back to, you know, what is foreseeable, what is reasonable under the circumstances. You know, if we're talking, you know, the person who was the aggressor, okay, person who was the aggressor, they're holding the baby in their arms, you know, and even though you weren't the initial aggressor and you fire, you know, I could see a situation where somebody could say that's not reasonable under the circumstances. I think it probably depends on the scope of the threat. You know, it also makes me think about a felony murder situation where, let's say that this man, not that he would do it, but this man right here is trying to rob me, okay, and I, in self-defense, you know, pull out my gun and fire, the bullet passes through him and hits this young lady right here and kills her, then under the felony murder statute, he's guilty. If someone dies when you were committing a felony, even if you weren't the one who pulled the trigger and did it, then you can be charged with murder. Okay?
So you shot me, went through and got her, so I'm guilty of murder.
Yes. Yes. That's how the felony murder statute works. Yes. And that would be, I think it would, if the aggressor is committing a felony, and they probably would be, then they would be charged with, you know, felony murder, you know, assault, or whatever. That intent would be transferred to him and off of you, as long as you were justified.
There was a case, I believe it was in Baldwin County years ago, where that something similar to that happened.
It's happened. There was, I'm not sure if we're talking the same one, but there was another case where, or one case where you had two robbers go in to rob a liquor store, and the shopkeeper shot and killed one of them, and the other one got out the door. The one who got out the door was charged with felony murder of his accomplice. Yeah, same thing. Other questions?
Is there something that goes against you having military training in a self-defense? Because a lot of your vets are well trained in the use of handguns and weaponry. As say against somebody that just pulls out a gun and randomly just starts throwing bullets everywhere.
You know, I could see it more in the civil context than in the criminal context. But you know, when it comes to, you know, what's reasonable, reasonableness is normally for the ordinary person under the same or similar circumstances. And you know, I would usually argue that, you know, what's reasonable for one person is reasonable for another. But I can tell you this, I've seen situations, civil and criminal, where someone who uses defensive force gets charged or sued, and their Facebook page has got, you know, all kinds of pro-gun stuff, you know, training, things like that. Someone could see that, you know, print that off, get a screenshot of it, and argue, well, this guy's just trigger happy. That happens sometimes. And so I don't think the training can necessarily be used against you, but I think if there are things out there in the universe, people might try to make an argument. Now, the counter argument is that that's unfair and prejudicial, but I think it's something to be aware of, for sure.
I have a question for you. Say you're out in public, so we're all sitting here eating, someone comes in shooting everybody. If I'm able to shoot the gentleman, and he's facing towards that, and I'm able to shoot him, so what is my stand your ground?
Stand your ground would apply because, well, assuming you're where you have a right to be, which you do, it's open to the public, you're not the initial aggressor in that situation, and you're not breaking any laws, then yes, that's a classic. I mean, it's defense of another and self in that situation, and so you have the same rights in this restaurant that you have in your own home. Yes. Yes. There is no jurisdiction. Yes, sir.
So, if they have a sign on the door, no weapons, you broke the law, so you're liable, right?
Well,
It's not illegal?
No.
that question has come up at every BamaCarry meeting I've been to, and I don't know the answer to that, sir. And I think that eventually the courts will end up deciding that. It's an unsettled area. They say, well, you're breaking the law, and then there's also the counter argument. Well, it's not legal to tell me what about the Second Amendment?
There's not a law.
Right.
There's not a law saying you can't carry it. It's just the establishment's rule.
Right.
You're not breaking the law.
Right. And so, of course, the establishment would say that we have a right to determine who comes in, and if somebody brings a gun, you're right. But I think we are headed for the appellate courts in Alabama to decide that issue. Now, let's say that you lost your stand your ground hearing because of it. Say you were breaking the law. You would still have self-defense and defense of another available as a defense in court. You just wouldn't have the stand your ground immunity that would bar you from being prosecuted.
What kind of jury would convict a man that saved a lot of lives?
Well, exactly, and I think it would be very hard to get a jury to convict you in that situation. And remember, DAs have got prosecutorial discretion. I don't know any DA who would want to prosecute that case.
There's some crazy ones.
A friend of ours, who is a police officer, told us that we could carry, even though they had a sign saying you were not allowed to bring a firearm in, because a police officer can bring one in. Because it's not a law, and all they can do is ask you nicely to leave. If you do not leave, then you are trespassing.
I think that's a pretty fair explanation of it, that you haven't broken the law, but if you unlawfully remain after being asked, then that would be breaking the law. And then if you're in a state of active trespass, and something like this comes up, then I can see stand your ground being out the window. Yes, sir.
Well, let's say you're in a situation where someone is clearly intending to do you harm, and there's no question that they were intending bodily harm to you and your people.
Yeah.
You shoot him and keep shooting. He's on the ground and you still shoot. Because what limit is there to when a reasonable person would have determined that the threat is no longer there?
Well, that makes me think of this gentleman talking about military training and firearm training, and the military and the police. They, in their training, they tell you to eliminate the threat, and whether if it's one shot that eliminates it or multiple. I think it's going to go back to whether the first shot was reasonable, because once the battle is joined, I think the first one
Once
is
you join
going
the
to
battle,
matter.
it's your job
Yeah,
to win it.
right. Yeah, I think so. Other questions? Well,
Is there any rules there in the federal property, like a post office,
Yeah, I'm pretty sure there's the federal statutes are going to control on that. I wouldn't want to carry one in a federal building. I think in that situation it clearly would not apply. Okay. All right.
I just, one other question or a comment.
Sure.
I think it is so absurd for people who have a concealed carry permit. It's a felony to go on federal property. That is, and people don't know it. People do it every day.
Right.
They can go arrest anybody they want to, just about.
Yeah.
It's just, it's infuriating.
Well, and I'll mention this for those of you who travel. You need to be careful about where you go. All right, the laws differ from state to state. I was consulted by someone from Alabama who went to the state of New York. He flew to New York. Now, when he got to the Birmingham airport, he checked his firearm, like you do when you're flying with a gun. Went through everything with the airline. All right. He flew to New York, and once he got to New York and took possession of his firearm, he was arrested. He was arrested because he had some ammo with it in a bag, and even though it was good enough for the airline, it was not good enough for the state of New York, and I had to connect him with a criminal defense attorney in New York City. So it's before you travel, take a look at what the laws are, because they're different in other places. And I don't know those of you who have your permit, probably all or most of you, but where I'm from in Coleman County, we've got a pretty good sheriff in Coleman County, and the permit there has the states who recognize this permit on the back. Show the viewing audience. You know, it's and it's quite a few states that do, but sometimes laws change in those states, you know, from time to time. So it's something to keep an eye on.
Was he arrested only because he had the ammo with him? Would he have been without the gun, been without the ammo?
I think it had to do with it wasn't just the gun. I think it was because he had the ammo with it.
When we buy our pistol permits, they give us a piece of paper on which states will allow and won't allow.
Yeah.
But we don't have it on our IDs.
Yeah. Good to have it on there. All right. Well, yes, ma'am.
I have one more question. I'm sorry.
That's all right, talk about the state. So if you're going on vacation and you're taking your firearm with you and you go through a state that doesn't allow you to have a firearm,
Well,
what are you supposed to do with it?
well, so it's not so much them not allowing you to have your firearm. A lot of them say it can't be loaded in a car. The ammo can't be kept with it, which kind of renders it useless. I went to Hawaii. In Hawaii for a family reunion. He planned it for 2 years. All right, carried his gun with him. Got a rental car. Put his pistol, and I think it may have been loaded. Had it in the console of the rental car, and then dropped it off with the valet. Well, and just left it in there. Well, the valet, I don't know if he was nosy or looking for something to steal or what, but the valet opens it up and sees the gun. The valet calls the police and says, "Hey, there's a loaded gun, in this car here." Well, at this point, this man who has never committed a crime or has no criminal record at all, he's on the beach with his grandchildren having a luau, and the cavalry comes for him. 8 police officers come and get him, take him to jail, charge him with a felony. You know, so it's just important to know what the law is there about, you know, the storage and what the requirements are. Yes, sir.
With reference to a concealed carry permit, would a restraining order from an ex-wife be grounds to deny concealed carry permit?
It could be. It could be. A few years ago, there was a law that made it harder to deny a pistol permit. But you know, generally the grounds are, you know, are you under a restraining order? Have you been under a restraining order? Do you suffer from any mental disease or defect? Are you under indictment? There's a list of things that can be grounds for revoking or denying a pistol permit. Under the law that was passed a few years ago, if your permit was denied, there is a process for taking the sheriff to court and having a trial within 10 days in district court over the issue of whether your permit should be reinstated. And it's also loser pay. If the sheriff loses it, they have to pay, you know, your legal fees. But there are several grounds by which they can legally pull a permit, and sometimes that's one of them. Yes, ma'am.
On what he was asking, if a felon who has been reinstated by the state of Alabama and gets a permit and has to stand his ground. Now, because the federal government says no,
Yeah.
but the state says yes,
Yeah.
what is the gentleman's or female's perspective?
Well, yeah, and we're in this standoff now where you had some sheriffs who were granting pistol permits to people, and the federal government said we're going to pull the federal firearm licenses if y'all don't, you know, change the way you're doing it. Yeah, I would say that that's a situation where you might have a conflict between state law and federal law. Most prosecutions go, you know, so if he's charged with a crime, are going to be in state court and not in federal court. I could argue the issue either way, but I would think that if he has a permit from the sheriff, that's probably a stronger position to be in.
Because with the state of Alabama, the gentleman that I know, the state of Alabama went ahead and took him, gave him full immunity
Yeah.
and reinstated everything.
Right.
So with the state of Alabama reinstating him, would that not go with federal?
I think, well, if there's been a full reinstatement of rights, then I would think that he's got as much right as anybody else. Okay.
Thank you.
All right, well, thank y'all for having me. If y'all have any questions, feel free to call me, email me, get in touch. Be glad to talk with any of you at either time.
I wanted one thing, I meant to get it earlier that I wanted to ask you about.
Yes,
and it doesn't actually pertain to the stand your ground thing. But I would like you to express, what are you supposed to do if something happens and you pull a trigger? And the police pull up out there, the first thing, because I've heard it explained, you know, for 2 or 3 days. The very first thing I've heard, all of them that was spoken to said, first thing you do is you say, I need a lawyer. And that's it. If you're, I mean, that, you know, when the cops come and pick you up and like the guy at another place said, you know, the police are trying to sell, they are very nice when they pick you up in this, because what they're trying to sell is prison. And what do you do, or how do you react if you are in a situation where you have to pull a trigger and shoot somebody?
I've got a 2-word answer. It depends. It depends. You know, if I stood here and said, don't ever talk to the police, you should always say I want my lawyer, you know, here's his number, 256-739-5005. You talk to him and not me. That would be a short-sighted disservice to you if I said that applied in every situation. If I stood here and said, talk to him, tell him why you're not guilty, that could be a disservice to you as well. Okay? I've seen situations where people have cooperated with law enforcement, and it went away. And they said, this is obvious, you're not guilty of anything. I've seen situations where people said, hey, you know, get off my property, call my lawyer, and then, you know, law enforcement pushes back. Every situation is different, and there's not a cookie cutter for what is the right course in a given situation. Now, most lawyers would tell you, you know, invoke your rights, don't talk to them, you know, they're out to get you, tell them to go through your lawyer, and that's the easy answer to give. My answer is it depends.
Can I ask you one more question, please, sir?
Yes.
What he asked, okay, say that he believes that he has the right for standing your ground, and he is a Bama member. So when does he contact you to help him?
Well, the SDF, the USCCA, those provide coverage. They have a 24-hour hotline. They have the cell phone numbers of their attorneys who are on call. And so if you've got that coverage through those organizations, they can usually get a lawyer to you in short order, on the spot. I mean, the last one I had, I got called at night. It was after normal business hours, and I made contact, within 30 minutes. So in that situation, it's.
I hope so, because I got this insurance.
Well, yeah.
I want you calling back.
Well, yeah. Well, and
You got
that's
me, and I really would like to talk to you.
And that's the thing, is, if someone is in that situation, be able to get in touch with your counsel as soon as possible. And your lawyer will tell you, what needs to be done.
I've been told times that if you have to shoot to empty your gun to make sure nobody think you don't get it and use their name. Is that true or?
Makes sense to me.
Shit till you don't have any.
Well, that's the situation that I mentioned in Walker County, where the truck came after my client. That is exactly what he did, and that kind of goes to your question from a few minutes ago. He emptied his magazine, and the fact that he did not make them more inclined to try to prosecute him. So.
Seriously, I think that's what the police do. I think that's what the training does, police. Somebody's shooting them, they have to redid it for them.
Well, yes, sir.
I say mine one step further.
Yes, sir.
Okay, like I say, I have a restraining order from his wife. Does that in any way take away from my open carry privileges or even any of my privileges of owning a firearm?
Well, so there are a couple different kinds of restraining orders. All right, there are a lot of divorces out there that will have a restraining order, even a mutual restraining order against harassment or coming around or anything like that. That's not the kind of restraining order that really affects your gun rights. Where it affects your gun rights is if it's a situation involving a PFA, which stands for Protection from Abuse. Okay, if a judge has a hearing on a PFA in open court and determines that that person committed the abuse complained of, then yes, that can have a lasting impact on your gun rights.
I'm sure you're gonna know this judge's name, Judge Hardeman.
Who?
Judge Hardeman.
I know Judge Hardeman.
He initiated all this. And this has been over 8 years ago.
Was this in Coleman County?
It was.
Okay.
PFA came from Judge Hardeman, and the charges that were brought against him were brought in the U.S. Attorney. Well, they allowed charges to be placed on administrative list for discharge. But Judge Hartman supposedly, after the PFA that he initially issued set to expire, set a trial, which I never knew nothing of, Judge Hartman made it permanent. I didn't find out about this for almost 3 years. During this time, I had bought 2 weapons. And when I went to get the third one, they came back and said, you need to check Coleman County. So I went to the clerk's office and on the whole thing. I had no knowledge of it whatsoever. So we debated it down, or I got back my lawyer, and finally I had to bring my ex up on contempt of court charges, but there in that case, it somehow in front of Judge Williams got swapped around. Well, okay, we'll reduce you down to a restraining order, and let her fly free. So does that have any bearing as far as my rights to? Because our last month's sheriff was here, he even indicated that I may not even get allowed on the loan now.
Have to look at exactly what the order says. I mean, I think certainly when you were under the permanent restraining order, that could definitely have an impact. If it was converted to something else, then the something else may or may not have an impact, but I think it certainly could. I mean, have you been denied a permit?
Yes, that's recent.
I think it's going to depend on the wording of the order.
But under I have the paperwork sent to the sheriff, and it clearly states that, I had to be allowed to participate. I knew nothing of it. I had to be served. I wasn't served. So it's just so many, fallacies in there that
well, generally, if you don't have service, then a judgment can be void. If you don't have service.
So Johnson was a lawyer, and I can't help but think he sent me down the road. But I have emails from him stating that there was no hearing, so that order is mute.
Well, when there is no hearing and it's just an ex parte situation, then it may have a short-term impact, but it eventually expires. And then, but if a judge has a hearing on it and makes a determination of abuse, that's when you get into a permanent situation.
It's a long story, but it's all, baseless. So, could you give me some suggestions as to what?
Let's talk after the meeting, okay? All right, thank you, sir.
What is the confusion about black powder versus centerfire ammunition? Some guys say, some of them had some of this court stuff come up, so I'm allowed to carry a black powder pistol, but I can't carry one that shoots centerfire ammunition. A gun's a gun, right? No. I mean, you get killed just as dead with a black powder. I shoot black powder. I mean, I'm not standing either side. But these guys have said, if I can carry my 44 Dragoons, and you can carry your 9 all day long, but I'm allowed to carry this, but I can't carry that. I mean, how can they carry one without the other, and not the other under the law?
I don't know. I have not heard that.
The ATF says that a black powder gun is not a gun. It's not a modern firearm. I'm just telling you, I can mail you one tomorrow, a black powder gun, and come to your house. I can't mail you a 9mm. That's ATF.
That was my question, is these guys that's got these questionable backgrounds where they can't get a pistol permit? I mean, it just broke my mind. But I've had 2 come to my church. They say, yeah, I can carry black powder, but I can't carry nothing else. Because they've had questionable stuff with someone on their license, this, that, and the other, can't get, single carry or anything like that.
I'm going to look into that. Yeah. That's the first I've heard of it.
Because if that's not considered as a gun, can you carry it on federal property, carry it anywhere you want?
Yeah.
I mean, can you,
it's questionable stuff.
Yeah, it's not a gun.
Loopholes.
But now the ATF says, because I got one in the other day for a guy, he went, the ATF says no, I don't have to have a signature when the black powder gun comes. I can mail it to the guy. I can put it in the US mail and send it. I can put it in UPS and send it. It's not considered a gun according to ATF. Now, according to feds, it may be, but according to ATF, it's not.
You just did, though.
Oh, yeah. Well, you know, he mailed a knife, he cut his throat. But the
He
ATF,
did set brass knuckles too.
but the ATF says with a black powder gun, it's not a modern weapon. And you don't have to have any kind of license to it. You can mail it, send it, do whatever you want to do with it. But you can't send the powder to load it with. You have to make it yourself.
I appreciate it.
All righty.
Thank you very much.
Everybody,
Thank you.
more of you. Thank
Y'all
you.
have-